filed a writ of prohibition to have Judge DeThomas removed. And then the appellate courts gave LIEnette 20 days to give legal reason why he should stay. And Silver Scam did. Except he screwed up quite a bit. And then we had 20 days to respond to his and her response. You're not going to believe what he said and what our response is to it. Citizen journalists coming at you with the news. WTH News reporting live, actually pre-recorded, about our response in the appellate courts in regards to Silver Scam and LIEnette's response to why Judge DeThomas should stay on this case. So if you remember, if you recall, Silver Scam said Jeremy didn't file in enough time. He waited this entire amount of time. Why? Why would he do that? Therefore, no, DeThomas should stay. Oh, that's right. He also said everything DeThomas said is the reason why DeThomas should stay. And then he quoted a case. Well, let me back up. He completely, totally misquoted a case. Anybody who gave LIEnette money, your money has been used and abused and you will never see it back. He completely misquoted a case that he, Mark Feather, and DeThomas were all involved in. And here we come full circle again, seeing all of this bias coming from Judge DeThomas. Here we are right here, 19-page document. I'm going to start sharing it with you here. And it says, in the district court in the appeal of Florida, Jeremy B. Hale's petitioner versus LIEnette Preston. Notice it doesn't say Michelle, Lacey, Alexis, LIEnette, because that's her legal name. And it fits extremely well. It's almost as if her mother was prophetic, going, I'm giving birth to a liar who will continue to lie habitually, pathologically, although she said in court psychologically. Well, I don't have any doubt part of the lies are because of psychological issues. Okay, so what happened is when we filed for writ of prohibition, then they get 20 days to respond as to why DeThomas should not be removed. And then we get 20 days to respond to their response. Now, this has already been filed quite a few days now, but I'm just sharing it with you now. This is petitioner's reply to respondent's response. Okay, so petitioner's reply to respondent's response to order to show cause. Order to show cause means the appellate courts ordered LIEnette to show cause why DeThomas should not be removed. Now, she didn't do it. Silver Scam did. Keep in mind, anybody who has tried to help LIEnette has further incriminated her, gotten her in further trouble. And I truly believe in my heart of hearts, Silver Scam doesn't want anything to do with this anymore. Not by any stretch of the imagination. He never knew what he was getting into. Now he's stuck in it and he wants out. But here we are. So, our response. It says the petitioner, as a matter of fact, George, let's just go right here. The petitioner, I may need help with reading upside down, but the petitioner, Jeremy B. Hales. Oh, that's what you call me. Jeremy B. Hales. By and through undersigned counsel files this reply to respondent's response June 4th, 2024 to this court's order to show cause, which includes a 2-item supplemental appendix containing Hale's motion for stay of proceedings pending petitioner for writ of prohibition, and hearing transcripts from February 28, 2024. Now that's pretty important. You have to understand that all the hearings, the video of the court hearings that are already up on YouTube, are being given to the appellate courts. Now, this is something that all the court systems in Florida now know. This is not a tiny podunk Levy County type of situation now. This is an entire state situation. The planet knows the name of Judge DeThomas. The planet has seen his behavior and what he's done inappropriately. And the planet isn't okay with it. And so that's all going to the appellate courts. They have it already. So essay, reference to the appendix, and already filed with the amended petition for writ of prohibition A. Okay, now that's page 1. So basically page 1 in a nutshell is saying this is what's contained within here in this response, which then gets us into our full argument. Okay. Now, I did not draft this. I paid for this to be drafted. And I've got to say that Randy and Doreen are, and particularly Doreen, are masters at their skill. Doreen is a wordsmithing queen, and she can get right down to the point. Now, I know a lot of you are thinking, when you see the word argument, you're thinking arguing, back and forth, arguing. Think of it more as a friendly debate in the court system.
A rebuttal.
It is a rebuttal. I think when people see argument, they go, women arguing. Well, that happens in real life, but that's not what's happening in the court system. This is taking what they said and going, this is why it's wrong, this is what's right legally. And Silver Scam is going to eat his words. As a matter of fact, if you want a visual picture, Doreen, in her eloquence of wordsmithing, takes everything he said and literally, word picture, jams it down his throat and says, suck it.
We call that dunking.
Oh, she dunked him and debunked him.
And debunked.
So we're going to start into the aspects of the argument, and it is priceless. So point number one, respondent argued right here. Respondent argued the wrong disqualification motion. Whenever the petitioner's legal team is starting a response to the response and stating that the lawyer Silver Scam, on behalf of LIEnette, literally argued the wrong motion, you know it ain't good. Now, I feel actually sympathy for those ignorant individuals who gave LIEnette money. I truly do, because you're never ever going to see any of it back. You would do better just to go out and start setting $100 bills on fire, because that would be more useful to you than giving it to LIEnette. At least you would get some heat, some benefit from that money, but it's gone forever, misused. As in point number one, respondent argued the wrong disqualification motion. Boy, that legal team is just looking incredible for her. Okay. Despite respondent's references to Hale's writ petition filed on March 1st, 2024, the operative filing is Hale's amended petition for writ of prohibition filed on March 25th. Do you see where Doreen is already correcting LIEnette's team with Silver Scam? Although neither relies on the December 2023 disqualification motion as a basis for seeking the writ, respondents' assertion that there was a delay of 65 days simply ignores the arguments actually made on behalf of Hales. Now, I really want to pay attention here, where this is what Silver Scam said. I delayed this for 65 days. And then that means he's ignoring and misquoting the wrong disqualification motion. In other words, not doing his job. Now, I get it. You probably get it. The guy doesn't want to he does not want to be her counsel anymore. Nobody would want to be this woman's counsel.
You think he did it on purpose?
There is that aspect. Did Silver Scam do it on purpose?
I mean, he submitted it 15 minutes before the deadline.
It's true. It was submitted, so they got it in 15 minutes before the deadline, and it's a mess, and it's so wrong. And the reality is, it could be. Silver Scam may just want this just to go away and sabotage, or it could be laziness, or it could be he's just sick and tired of LIEnette. The only person, this is true. I can't emphasize this enough. The only person that I have seen that has not wanted LIEnette as far away as possible from her is Crook, and I don't get it. She says the most vile, disgusting things about him, and he's still there. So is he a codependent within this narcissistic relationship? I mean, that's a viable option. He may be the codependent in this narcissistic relationship, and he has nowhere else where he can go. Maybe it's a trauma bond. She has traumatized him so much that he can't break away from that bond. But everybody else wants as far away from her as possible. So let's keep going here. The very first sentence of the statement of facts and case of the amended petition states, this petition for writ of prohibition arises from the trial court's recent denial of 2 motions to disqualify Judge DeThomasis for bias filled in quick succession. And then it identifies 2 motions as Hale's second disqualification motion filed February 11th, 2024, denied on February 14th, and his third disqualification motion filed February 21st, 2024, denied on February 28th. Hale's amended petition clarifies that the December motion and related order were included in the appendix for context. Now, let's just pause right there. What Doreen is doing is setting the stage, saying this writ of prohibition just didn't come out of nowhere 65 days into this, which I still have a temporary injunction placed on me with no end date, which means it legally defies what a temporary injunction is. Months upon months upon months where I can't even now protect myself under my Second Amendment right, protect my loved ones under my Second Amendment right. That's not right.
Keyword temporary.
But no end date.
Issued based on something you didn't do.
And Doreen is going to get to that point. None of this temporary injunction is based on me. It's based on lies that LIEnette stated about Mark Feather. So what she's doing is saying Jeremy has already filed motions, not once, not twice, 3 times within the 65 days for Judge DeThomasis to do the right thing, recognize his bias, what he has done is inappropriate, and recuse or remove himself from this case. Then came the writ of prohibition, following the procedure and the process, and it was Judge DeThomasis that took us to this point, not Jeremy Hale's. So we continue to go on. Hale's second motion, of course, was based on what occurred at the hearing on January 23rd, 2024. And his third motion was presented due to the independent grounds for disqualification created by the 2/14 or February 14th order denying Hale's second motion. Once the third motion was denied by order on February 28th, a petition for writ of prohibition was filed in the court on March 1st, 2024, addressing the 2 motions and the related orders, which were less than a month old at the time the petition was filed. Let's pause right there. 65 days. Jeremy waited 65 days. Jeremy delayed 65 days. First of all, he misquotes the wrong thing. And then she puts him in his place and says they were less than a month old at the time the petition was even filed.
So his math ain't mathin' either.
Can you imagine being the appellate courts and reading this from Silver Scam and then going and knowing and having the truth right in front of you? What do you think that does for Silver Scam's career?
Doesn't look good.
Not at all.
No bueno.
Not at all. Now, don't get me wrong. There are lawyers out there that want recognition. As a matter of fact, more than anything, they want me to say their name on a channel, on a video. It isn't going to happen. They will get no recognition from me whatsoever. As a matter of fact, I don't get it. I don't understand it that they would even thrive off of negative recognition. And you have the old adage, even negative PR is still PR. How would you like to be known as the lawyer representing LIEnette in this? I don't think so. I don't think anybody is that foolish, and yet there are those, for the momentary fame that they think they will receive from this, that's all they desire. That's foolishness. That's very short-sighted instead of long-view looking. So on May 15th, 2024, this court acknowledged and accepted Hale's amended petition for writ of prohibition filed March 25th. Now, while the prohibition is not among the extraordinary remedies that are subject to jurisdictional time limit, the general timeless rule requires petitioner to act as soon as practical, which is grounded in reasonableness. And then what you have is Snow versus State right here. So what Doreen is doing is citing law, okay? And let me emphasize that law yet again, that this general timeline rule requires a petitioner to act as soon as practical, which is grounded in reasonableness, okay? So here's the reality of it, right? Keep that in mind. Practically as soon as possible, grounded in reasonableness. The disqualification motion was timely filed on day 19 of the 20-day deadline permitted by Rule 2.330G. The judge denied it on February 14th in an excessive overwritten order that itself became independent basis for disqualification. So if you understood what Doreen just said, Judge DeThomasis gave even more reason to have him removed from this case in his denial of the motion to remove himself. As such, a third disqualification motion was presented 1 week later, addressing the independent basis for disqualification created by the February 14th order. It then took, not Jeremy Hales, Judge DeThomasis 7 days to deny that one, which he did at 9:47 a.m. on February 28th, 2024. Hale's counsel filed his motion for stay right here, George. Hale's counsel filed his motion for stay 8 minutes later at 9:55 a.m. 8 minutes. Now, I know what you're thinking, the same thing as I'm thinking. I wish it would have been 15 minutes. Yes, we all wish it would have been 15 minutes. All right, so let's go back here yet again. While prohibition is not among the extraordinary remedies that are subject to jurisdictional time limit, the general timeliness rule requires a petitioner to act as soon as practical, which is grounded in reasonableness. And what did I do? 8 minutes later.
8 minutes later.
If it only was like SpongeBob. If it only was. 8 minutes later. And yet, Silver Scam wants to say that I delayed this entire process 65 days. The writ of prohibition came in after 8 minutes. Not 8 days, not 8 hours, 8 minutes later. Consider you being the judges in the appellate courts, reading what Silver Scam wrote, and then reading reality, but having the evidence, all the screenshots, all the video, all of the court documents, having the actual true evidence. How credible do you think Silver Scam is now? The answer is very easy. And by the way, judges look at credibility. If you listen to the Ohio courts, and the judge in the Ohio courts continues to tell LIEnette and Crook that she is judging based on their credibility or lack thereof. She knows they're lying. The proof is there that they continue to lie. And she finds them not credible. She finds Jeremy and George credible. The evidence backs up Jeremy and George. The evidence is incriminating towards LIEnette and Crook. So now you've got Silver Scam in this situation in the appellate courts, which frankly, he's probably not very well liked in the first place. And now looking even more foolish. His own words coming back to haunt him. And you know what the worst part of it is? It goes back to haunt LIEnette, and that's not even the worst of it. There are individuals that gave her thousands of dollars. Thousands. And they'll never see any of it, and will never have any fruitful...
There are those that donated and don't expect it back, but there are those that donated thousands with the anticipation of getting it back, thinking that she was innocent and would win. Those are the people I feel bad for.
The funniest thing is they think she's actually innocent when all the evidence is already proven, even in the Ohio courts and more in the Ohio courts, and will be in the federal courts. She's guilty. All right, so 8 minutes later, the parties and the counsel were required, pursuant to scheduling order, to appear in court that very day at 1:30 p.m. to argue substantive motions. However, the only item addressed in court on that afternoon of February 28th was the motion for stay. The time span between rendition of the order denying Hale's third disqualification motion and the parties' live court appearance was 4 hours, with the filing of Hale's original petition for writ of prohibition in this court occurring approximately 40 hours thereafter. All right, so we understand what the first part of the argument is. First part of the argument is Silver Scam argued the wrong disqualification motion. He can't even get his facts right. Now, I get it. LIEnette has very little money. He isn't going to do any work, and he knows his client's guilty in the first place. The second point of argument, as we look right here, preservation or preservation. Can you read that, George?
Preservation applies
to disqualification. Okay. All right. We're not talking about jams and jellies in jars, preserving that way, but it's the preservation of, well, let's just read through it together, okay? Respondent notes that on February 28, 2024, Hales filed his first and only request to stay in the trial court proceedings to seek relief in this honorable court, okay? So what Silver Scam said is he's delayed all of this. This is his first and only request to stay the trial court. Now, keep in mind, stay means to pause, to stop, and to remove. Truly, to remove, Judge Thomas says. So Silver Scam says, Jeremy's only filed once. Only one such request was required. However, because preservation applies to disqualification matters, the purpose of the preservation rule is to notify the trial judge of possible error and offer a chance to correct it at any early stage. The preservation requirement also serves the purpose of treating the parties, the court, and the judicial system fairly, as we see right here in Citizens of State versus Clark. All right, so what is this preservation that we are applying here? It says we're not going to come right out the gate and file for a writ of prohibition against Judge Thomas. We're going to tell him, hey, you're being biased. This isn't okay. You need to remove yourself. That's what the law states. There has to be an opportunity for Judge Thomas to actually correct his matters and put another judge on this. Not only was one opportunity given, 2 opportunities were given. Not only were 2 opportunities given, 3 opportunities were given for Judge Thomas to actually do the right thing. And he refused. As a matter of fact, every time he refused, he actually broke the law even more. All right, so on February 14th, 2024, Judge Thomas denied Hale's second motion to disqualify in a 5-page, single-spaced, 2,549-word order, which refuted the allegations in the motion and attempted to justify his own inappropriate conduct with unjustified attacks on Hale's lawyers. Now, we're going to get back to that in a second. His job as a judge is to listen and then make a decision at the end. His job is not to act as legal counsel for LIEnette because she didn't have one. His job isn't as a judge to actually sit me down and cross-examine me. His job isn't to keep speaking and speaking and speaking. You would think that this man would be a YouTube star by now for as much as he speaks.
He does have a channel.
With no viewers, yeah, and no followers, yeah. I get that. I do get that. So
I shouldn't have subscribed because I subscribed.
Oh, well, I mean, isn't that what everybody says? Subscribe! Click
Like!
the bell! Like! Comment! Listen, you can like and you can comment all you want. It truly does nothing for the system of YouTube at all.
It used to,
but most Most content
Not
creators, most
anymore.
influencers don't even understand the platform that they're on YouTube. So comments, while we appreciate them, it doesn't do anything for the video. Thumbs up, thumbs down, doesn't do anything for the video. YouTube still has it there, but it doesn't do anything. If you really want to help a content creator, watch a video from the very beginning to the very end. That's what helps a content creator. Subs don't even help a content creator. It's views that helps a content creator. But he's not a successful content creator, nor is Judge DeThomasis a very successful judge by any stretch of the imagination. So we have this aspect where DeThomasis denies and then further, as we see here, justifies his own inappropriate conduct with unjustified attacks on Hale's lawyers. Let's see what she has to say here. Respondents state rather inexplicably that the petitioner filed his third disqualification motion on February 21st at 2024, in which the petitioner explicitly states that his third motion is based on the order denying his second motion. There is nothing inexplicable about that process. Judge DeThomasis created an, what's that, George? Independent basis for disqualification within his February 14th order. So, in other words, there's nothing inexplicable about it. Judge DeThomasis created his own disqualification order by breaking the law and not doing what he was supposed to do. And then it says, therefore, the preservation rule required that a successive disqualification motion be presented. So, remember what the preservation rule is right here. Point number 2 in the argument. First one is he didn't even argue the right motion. Second is preservation applies to disqualification. The rule states that you've got to let the judge know he screwed up and he needs to remove himself. That's the rule. And that was done once, twice, 3 times a bad judge. To give the judge an opportunity to rectify his transgressions of Rule 2.330H and disqualify himself due to the independent basis that he alone created. Judge DeThomasis, however, declined, and we are now here. Now remember, Silver Scam said Jeremy created this huge mess. He delayed this whole process for 65 days. And what am I saying? Through Doreen? Well, I'm saying, and Doreen is saying, and she is my mouthpiece, that Judge DeThomasis created this entire mess by not removing himself when he legally should have. In other words, he created a delay. At no time did me, myself, my counsel, George, Mark Feather, Randy, Doreen, or anyone else create any type of delay in this court hearing. Judge DeThomasis continued to orate so greatly, as if we were in a classroom, to teach us all we needed to know, all about him, all about the law, except it's not a classroom, it's a courtroom. His job's to listen, and at the end of listening, his job's to make a decision. Not to teach, not to act as a lawyer, his job's to listen. And he continued to do his job wrong. We can see here, right here, the rule requires that a successive disqualification motion be presented to give the judge an opportunity to rectify his transgressions of the rule. And to do what, George?
Disqualify himself.
Due to the independent basis that he alone created. But he declined, and that's where we're now here. And what's this? In what and what?
I can't pronounce the first one, but
Me either.
Alvarez.
There'll be another court case with Alvarez coming soon.
V. Alvarez.
So, yep. So there's this case right here. There will be another court case in Ohio with that. We see that the court notes that the preservation rule ordinarily requires a successive motion to be presented to the trial judge if a new basis for disqualification arises. Keep in mind that when Judge DeThomas denied disqualification, he created another reason for disqualification. And then he denied it again, and he created another reason for disqualification. The judge either says yes, granted, or denied for the motion for disqualification. He went on to write books and volumes of justifying his actions, which was completely and totally inappropriate. And Silver Scam is trying to rely on that in the appellate courts, saying, yeah, well, we agree with everything that Judge DeThomas said. And then he can't even quote the right motions as he's saying it. So it says that the facts of, can we just call this ANFAN or AFAN? Mm-hmm. We'll say AFAN. The facts of AFAN, okay, versus Alvarez. The facts of AFAN versus Alvarez, however, were unique because the trial judge denied AFAN motions to disqualify, which was not based on bias, but on the judge being a material witness. You know, the world wants to have, the planet wants to know if Judge Craig DeThomas is going to end up a witness as well.
Well, Silverman's already
Silver Scam is already going to be called. He's going to be deposed. He's going to be called as a witness in these cases. And because of LIEnette's lies.
Feather's now a witness.
Feather is a witness as well. And so remember and recall that LIEnette said that her lawyer, and this is all recorded, Levy County Sheriff has it, we have it, that she said her lawyer, Joshua Silver Scam, said that she could be there, that she had every right to be there at town hall meeting, which they are now in court for contempt of court in Ohio, yet again, for being there an hour and a half. No good lawyer. I cannot believe that Silver Scam, even though he's representing LIEnette, would ever tell any client to be there knowing there's a civil protection order. I refuse to believe it. I don't care how bad of a lawyer he is. He isn't that bad. No one would tell their client be there. So she's lying, or if she's telling the truth, oh my goodness, he shouldn't even have a license if she's telling the truth. All right. But the judge was being a material witness, and on the very same day filed a bar complaint against his attorney. Okay, so the judge was a witness, and then the very same day filed a bar complaint against his attorney, commenting negatively on her verdict and ethics, and strongly indicating that the judge distrusted the lawyer. Although the bar complaint created a new basis for disqualification, which is bias, like Judge Craig DeBiasis, AFAN did not file a successive disqualification motion raising the new issues, but simply argued both issues in his petition for writ of prohibition. Deeming these particular circumstances to be extraordinary, the court considered all arguments raised in the petition and granted the writ, stating, "The law does not require futile acts for the preservation of error." Okay. In other words, Silver Scam and LIEnette are screwed, is what it really comes down to. I mean, Doreen, in the most professional way, and this is the type of lawyer you want, complete and total fact-based professional, evidence-based professional, is saying, in Jeremy's words, suck it. All right, but let's keep going on because there's a lot more words, okay? Hales, on the other hand, did indeed preserve for review the independent issues created by Judge DeThomas's February 14th order in a 50-page successive, i.e. third, disqualification motion filed 1 week later on February 21st. It should be noted that there were no court appearances between January 23rd and February 28th, 2024, and the trial date of March 1st had already been set in open court during the January 23rd hearing. This reading upside down thing is not easy. We both know I can't read anyway. So, basically, in a nutshell, what Doreen is saying is Jeremy and his team have gone above and beyond. Jeremy and his team have given Judge Craig DeThomas every opportunity not to actually be in this position of where we are right now. And yet he has further dug the hole. The same as LIEnette. She's been given a cease and desist. Then she went to court. Then she got a civil protection order. Now she's been found guilty in the civil protection order for violating it. She's going to be found guilty even more for violating it. I don't get it. Why do individuals continue to dig a deeper hole for themselves? When you first get the cease and desist, you should probably just, obey it. Why would anyone in their right mind want to cause further chaos, further cost, further, you put the name in there. Just stop. And it still to this day has not stopped. Now, in Silver Scam's response for showing cause of why that DeThomasis should stay on the case, he talks about this case called, do you want to take a stab at the name there?
Arroyo.
Arroyo supports Hale's preservation. Now, in Arroyo, you had Silver Scam, Mark Feather, and Judge Craig DeThomasis. As a matter of fact, Silver Scam is very, very aware of this case, and yet he screwed it all up.
Didn't he say it was deja vu?